Welcome to The Debate. So imagine getting a phone call, an extortion call actually, from someone claiming they've kidnapped your mother,
Which is absolutely terrifying.
right? And they demand a ransom. But to prove they aren't bluffing, they start reciting your personal, unchangeable information. I'm talking your exact address, your full legal name.
Details that prove they have a complete, robust profile on you.
Exactly. And the crazy part is, all of this happened not because you were targeted by some, international espionage ring. It happened because you used to work for a company famous for selling glazed donuts.
The disconnect there is just staggering. I mean, you expect a certain level of risk when you deal with a bank or maybe a government agency, but an employer in the food service industry suddenly becoming the weak link that permanently exposes your digital identity?
Yeah, it's wild.
It really highlights a profound vulnerability in our daily lives.
It does. And that extortion call, that's actually a real detail from the November 2024 Krispy Kreme data breach.
Oh, wow, really?
Yeah. The Play ransomware group infiltrated their systems. They stole highly sensitive information from roughly 161,000 individuals, primarily current and former employees. And we aren't just talking about like a leaked list of email addresses here.
Right, it was much deeper than that.
Oh, absolutely. They took social security numbers, biometric data, medical health records, and they published it all on the dark web.
And so now we're looking at the aftermath, which is a $1.6 million class action settlement. And this forces us to ask a really uncomfortable central question for today's debate.
Which is,
Does this standard class action framework, offering capped payouts and a year of credit monitoring, actually work as a pragmatic resolution for data breach victims? Or does it fundamentally fail to hold corporations accountable for the permanent, invisible costs of exposing immutable personal data?
well, I'll take the side of pragmatism here. Look, the reality of a massive data breach is just inherently chaotic. I mean, the legal system cannot unring the bell, right? No judge can issue an order that magically pulls a social security number off a dark web server.
Obviously not.
Right. But what the class action settlement framework does do is triage real-world harm efficiently. It provides immediate, scaled financial relief, and it forces vital corporate security improvements without the immense friction of, 100,000 individual lawsuits.
I have to push back on the idea of this being an efficient triage, though.
How so?
How so?
Because if we look closely at how these settlements actually operate, this framework treats catastrophic data negligence as a negligible operational expense.
You think so?
I do. It effectively shifts the lifelong burden of a stolen identity entirely onto the victims, offering them pennies on the dollar for a permanent exposure.
Okay, but let's look at the actual mechanics of the settlement before we just dismiss it entirely. It establishes a concrete tiered structure. If a victim has verifiable losses, say a compromised financial account or actual identity theft, they have a direct path to claim up to $3,500.
Which requires a lot of paperwork. Sure, but for the vast majority who don't have documented financial losses yet, they can still claim a $75 baseline payout, and they secure 1 year of credit monitoring. And this isn't just Krispy Kreme, by the way. We see this exact same architecture in the Capital One $425 million case or the Blue Cross Blue Shield antitrust payout.
But wait, you're comparing a stolen credit card in the Capital One case to stolen biometrics in the Krispy Kreme case?
I mean, they're both massive data breaches.
Yeah, but that's exactly where this framework falls apart. If you lose a credit card, you cancel it. It's an inconvenience, sure, but a biometric signature, your fingerprint, your facial scan, your detailed medical history, that is immutable.
Well, yes,
You cannot cancel it and get a new fingerprint issued in the mail. Because this data is unchangeable, the real-world impacts are catastrophic.
I completely acknowledge we are dealing with a higher tier of sensitive data here.
Exactly. I mean, we already mentioned plaintiff Maria Alvarez and that horrifying kidnapping extortion call. Look at plaintiff Heather Robison.
Right. The spam calls.
Yeah, after the breach, she started receiving 10 to 20 targeted spam and scam calls a single day. It got so severe that she actually missed a vital, legitimate phone call about her own son being injured in an accident.
Oh, man.
She missed it because she assumed it was just another scammer trying to leverage her stolen data. So, when you take a $1.6 million settlement and divide it among 161,000 victims whose lives have been permanently upended in ways you cannot easily put on a spreadsheet, it doesn't look like accountability. It looks like an admission of corporate convenience.
I hear the frustration there, I really do, but we have to ground this in how the law actually functions, not how we wish it functioned. I want to use your spreadsheet comment to explain the underlying logic here.
Okay.
Think of this settlement framework like a medical triage unit during a mass casualty event.
A triage unit?
Yeah. The doctors in that unit cannot undo the disaster. They have limited resources and they absolutely must allocate their care based on demonstrable bleeding wounds. The legal system requires the exact same thing, a burden of proof.
But a triage unit in a hospital still treats invisible injuries, like concussions. The legal system is ignoring the concussions entirely.
It isn't ignoring them, it's prioritizing the acute financial hemorrhaging. Look at the plaintiffs in the complaint who suffered concrete disruptions. Exactly. Dwayne Hobson had unauthorized DoorDash subscriptions charged to him, fraudulent Apple Card charges, and someone even successfully applied for a fast loan in his name. It completely tanked his credit score.
Right.
And Kimberly Thompson had a $571 fraudulent charge on her Discover card and was subsequently denied a personal loan by her credit union. The $3,500 tier in this settlement is a direct, engineered path to restitution for those exact, demonstrable financial wounds. It places the money where the paper trail proves the harm occurred.
Okay, but if you're listening to this right now, you have to be wondering how you are supposed to generate a paper receipt for the panic attack you had at 3 a.m. because your Social Security number was leaked to a ransomware group.
Well,
You can't. And that is exactly the blind spot of this settlement. You mentioned the triage unit demands proof, but what does that triage actually demand of the traumatized victims?
it asks for documentation.
It forces them to navigate complex legal claims portals, dig up financial records, and submit everything by strict deadlines, like the impending June 2026 cutoff for this case.
But that's why the $75 baseline exists. It's precisely for the people who can't provide that documentation.
$75 for a lifetime of anxiety? I mean, let's break down why that's grossly inadequate using the Identity Theft Resource Center data, which was cited in this very context.
The ITRC study, yeah.
Their studies showed that 73.8% of identity theft victims reported being, quote, generally inconvenienced, which sounds minor. Right. Inconvenienced is a sterile word for what is actually happening. Over 55% of them missed time away from work just trying to freeze credit in contact banks. Over 60% had to borrow money from family to cover stolen funds.
It's definitely a hassle.
It's beyond the hassle. Beyond the finances, there is a massive psychological toll. Plaintiff Dwayne Hobson stated he went into a deep depression over the sudden financial ruin he was facing. Suzette Kastman wakes up in the middle of the night terrified of what criminals are doing with her data.
I'm not denying the psychological impact.
But the legal requirement for verifiable financial loss systematically dismisses that invisible yet entirely debilitating psychological reality of a data breach.
Look, you have to realize why the legal framework defaults to financial caps and strict requirements for proof. It isn't a lack of empathy, you know? It is the mathematical reality of keeping the system solvent.
Solvent for the corporation.
Solvent for the settlement fund. Courts deal in damages that can be quantified. Let's say we agree that the anxiety is worth compensating, and we allow purely subjective claims without any documentation.
Okay.
If every victim who felt anxious was awarded just $1,000, the $1.6 million settlement fund would be completely depleted after the first 1,600 people.
Well, maybe the fund should be bigger.
But based on the current fund, that would leave over 159,000 victims, including Kimberly Thompson and Dwayne Hobson, who have actual calculable financial deficits with absolutely nothing. The burden of proof, the receipts, the portals, that friction is what ensures the money actually reaches the people who had money stolen from them.
Solvent for the settlement fund, sure. But it artificially limits the corporation's exposure. And this leads us to an even bigger structural flaw, honestly.
Which is what?
We've talked about how harm is proven, but we need to talk about when it occurs. The temporal mismatch between the settlement's benefits and the criminal's methods is just staggering. I mean, the settlement proudly offers 1 year of free credit monitoring.
Which is the industry's standard immediate protective measure. It catches fraudulent accounts being opened.
It is standard, yes, but it demonstrates a fundamental misunderstanding of how the dark web economy actually operates. The legal complaint details the concept of FULZ packages, FULLZ.
Right, the full profile packages.
Exactly, but we need to unpack what that really means. Cybercriminals operate in a highly specialized, layered supply chain. The people who break into Krispy Kreme, like the initial access brokers or ransomware groups, they usually aren't the ones taking out a fraudulent loan in your name.
No, they're just breaking down the door.
They blow the vault open, steal the raw data, and sell it in bulk to aggregators.
Right, and those aggregators act as data brokers for the black market.
Exactly. The aggregators take your stolen Krispy Kreme data, your biometric scan, your social security number, and they cross-reference it with other unregulated data. Maybe they buy your phone number from a 2019 social media leak.
Or your driving history from a DMV breach.
Precisely. They stitch it all together to build these FULZ packages, a complete, actionable synthetic profile of your entire life.
Which command upwards of $100 per record on the dark web, as the source material notes. It is a very robust, sophisticated economy.
And here is the critical mechanism that undermines the entire settlement. The U.S. Government Accountability Office, the GAO, released a report explicitly noting that this dark web supply chain operates on a deliberate time lag.
A time lag?
Yes. Stolen data is often held by aggregators for a year or more before it is finally sold to the end-stage fraudster who actually tries to open a credit card in your name.
Ah, I see where you're going with this.
They sit on the data, they wait for the media heat to die down, they wait for your hypervigilance to fade, and they strike later. So, that 1 year of free credit monitoring offered by the Krispy Kreme settlement, it is perfectly timed to expire at the exact moment the victim's lifetime of risk truly begins.
Well, corporate liability vanishes right as the fraudsters actually go to work.
Okay, that is a very compelling breakdown of the threat landscape, I'll give you that. But you are artificially narrowing the scope of what a class action settlement actually achieves here.
How so?
You're looking purely at the payout and the credit monitoring, treating them as the sum total of the legal victory. But in massive federal litigation like this, the true lasting value isn't just the checks. It is the injunctive relief.
By injunctive relief, you mean the mandated security upgrades. Precisely. The court isn't just handing out money and letting the company go back to business as usual. These settlements compel incredibly strict, systemic overhauls that the free market entirely failed to produce on its own.
Sure, but
Let's unpack the jargon in the complaint because it really matters. The lawsuit demands the company adhere to the NIST cybersecurity framework and mandates FTC and HIPAA compliance standards.
right.
But what does that actually mean for the consumer? It means the company is legally ordered to implement end-to-end encryption. It means segmenting their data with internal firewalls, so a hacker who breaches the payroll system can't just pivot over to the medical records.
Which, let's be honest, are basic competencies they should have had on day one.
But they didn't. And government regulation is notoriously slow to adapt to cyber threats. The law hasn't kept pace with technology, which means private litigation is effectively acting as the regulator here.
It's acting as a band-aid.
It's acting as an enforcer. The settlement requires Krispy Kreme to engage independent third-party penetration testers. They are being forced to undergo what's called a SOC 2 Type 2 attestation.
Which is an audit.
But it isn't just a paperwork exercise. It means an independent auditor is hired to actively stress test and attempt to break into their servers every single year for the next 10 years to prove the defenses actually work.
Okay.
The legal action forces the company to stop treating cybersecurity as an optional overhead cost, and it mandates the prevention of future breaches. The value here is structurally guaranteeing the future safety of millions of people's data.
Look, forcing a company to adopt encryption and undergo penetration testing is undeniably positive. I'm not arguing against better security,
Good.
but let's use an analogy to understand what that actually accomplishes for the victims of this breach. Framing this injunctive relief as a primary victory is like forcing a company to install a state-of-the-art laser grid security system. after they already left the front door wide open and the vault was entirely emptied.
I mean,
Yes.
it protects future inventory, but it does absolutely nothing to help the people whose most precious, unchangeable items were already stolen and sold.
But without the class action mechanism, what forces the company to buy that new security system at all? The threat of financial ruin should force them, but the stick just isn't heavy enough. You really have to ask yourself, is $1.6 million a deterrent, or is it just a calculated operational expense for a massive multinational enterprise?
It's a significant legal penalty.
Is it though? Look at the numbers. Experian released studies noting that the average cost of resolving medical identity theft alone is around $20,000 per incident.
Right, it's expensive to fix.
Against that reality, $1.6 million for exposing the immutable biometrics and medical health records of 161,000 employees, it feels like a rounding error. It doesn't sting. And if the penalty doesn't genuinely impact the bottom line, the corporate behavior doesn't change.
Okay, but the size of a settlement is never just an arbitrary number pulled out of thin air to teach a moral lesson. It is always a complex, calculated compromise based on the specific, verifiable damages that plaintiffs can actually prove in court, factored against the immense risk of losing at trial.
Which again highlights how the legal framework favors the corporation.
It highlights the difficulty of the law. Plaintiffs in data breach cases constantly struggle with what courts call standing, proving that they have suffered a concrete injury right now rather than just the risk of future harm.
Which we know is coming because of the time lag.
Yes, but the courts need proof today. If plaintiffs like Therese Banks, who spent 20 hours just researching the breach and frantically changing his passwords, or Joseph Das Reyes had to sue Krispy Kreme individually, they would be buried in corporate legal fees.
Probably.
Their cases would likely be dismissed for lack of standing, and they would see absolutely nothing. No $75 check, no security upgrades, nothing. The collective power of the class action is the only vehicle capable of extracting that $1.6 million and forcing the decade-long security audits.
I'm not arguing against the concept of collective action. We absolutely need it.
Okay.
My contention is that the current framework of that action is structurally biased toward limiting corporate liability, entirely failing to account for the lifelong, predictive nature of digital exposure.
Give me an example.
The clearest example of this failure is plaintiff Andy Lavor, who is representing his minor daughter identified in the complaint as IL. She is under 18. Her credit history is completely unestablished.
Right. She's a kid.
And her social security number is now permanently sitting on the Play ransomware leak site. The criminals know she is a minor. They are simply waiting for her to turn 18 so they can ruin her financial life before it even begins.
That is definitely a tough situation.
It's devastating. A $75 check and a year of credit monitoring while she is a child does absolutely nothing to protect her when she tries to apply for student loans or buy her first car in 5 years.
That is genuinely one of the most difficult edge cases in privacy law. I'll agree with you there. The framework absolutely struggles with long-tail predictive harm for minors. But once again, the law requires judges to operate on the evidence of today, not the hypothetical crimes of tomorrow. I mean, how could a court assign a monetary value to a loan denial that might happen in the year 2030?
It's not a hypothetical crime if the behavioral science of cybercrime, documented by our own government agencies, explicitly tells us that criminals intentionally hold the data for years to weaponize it later.
The intent is there, yes.
The legal framework is choosing to ignore the established reality of the dark web economy simply because it's too complicated to quantify.
It isn't ignoring it, it is recognizing the jurisdictional limits of the court system. That is exactly why the injunctive relief is the actual anchor of these settlements. We cannot predict the future, so the most responsible legal action is to lock down the network moving forward so IL's future employers don't expose her a second time.
But it doesn't secure the data that has already left the building. That data, her immutable identity, is out there forever.
Well, as we step back and look at the entirety of what we've discussed today, I think we've mapped out the tension perfectly.
I think so too.
From my perspective, the aftermath of a massive data breach is legally and practically chaotic. And while it may not offer perfect, lifelong restitution for the profound psychological toll and the abstract anxieties we all share, structured class action settlements remain the most pragmatic, evidence-based mechanism we possess.
Right.
They successfully extract real corporate concessions, they legally mandate rigorous security overhauls like continuous SOC2 audits, and they deliver timely financial relief to those who can demonstrate acute harm.
And my view is that pragmatism shouldn't be a convenient shield for negligence. Until our financial penalties accurately reflect the permanent, catastrophic severity of losing one's digital identity, these settlements will remain fundamentally inadequate.
You see them as just a slap on the wrist.
Exactly. We are talking about immutable data. You cannot change your fingerprints, your medical history, or your social security number. Offering a heavily capped payout and a single year of credit monitoring for a literal lifetime of risk is, as the source material beautifully phrased it, a wake-up call wrapped in powdered sugar.
That is quite the phrase.
It is, because it treats the permanent exposure of 161,000 people as a minor cost of doing business, completely failing to deter the institutional negligence that left the vault unlocked in the first place.
Well, despite that deep structural disagreement, we clearly share a profound consensus on the underlying reality here.
Oh, definitely.
The modern digital economy has created a sprawling, inescapable crisis of institutional accountability. To simply participate in society today, to get a job, to open a bank account, to just exist, consumers are forced to surrender highly sensitive, immutable data to corporate entities.
Absolutely. We are required by the structure of modern society to hand over the keys to our digital lives, often to institutions that clearly view cybersecurity as a secondary, optional concern.
Which is terrifying.
It is. The sheer volume of these breaches highlights a systemic vulnerability in how our global economy operates. The invisible costs of the digital age are compounding quietly day by day, and the victims are the ones paying the interest.
We just remain deeply divided over whether the current legal framework is the best possible tool for managing this crisis in real time, or a flawed system that favors corporate risk absorption over individual privacy.
Which guarantees this is a conversation that is far from over, both in the federal courts and in the way we regulate data broadly.
Indeed, navigating digital identity in the modern era is deeply complex. When you think about a physical bank robbery, the aftermath is tangible. The vault door is blown open, the safety deposit boxes are scattered across the floor, and you know exactly what is missing.
Right.
But in the digital age, the vault is invisible, the theft is infinite, and the exposure is permanent. It warrants a much deeper exploration of our own data footprints and the true, lasting value of the personal information we give away every single day. Who is holding your keys, and what happens when they lose them? Thank you for joining us on The Debate.